ZipForms. Oh, there it is. Hi, everybody. Welcome. Thanks for being here today. Hey, Joe, welcome back. Joe, I think I owe you some forms, right? I'm going to try to remember to send those to you as soon as we're done with the webinar here today. Leases are kind of important, so let's go ahead. I'm going to launch into it. We've got 50 something people registered for the class, and so obviously they're going to start coming in a little bit slow, but we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke. There's my telephone number, and there is my email address. I do look forward to talking with you. I have a broker's license in several states, and let's see what else. And you should get your broker's license, right? For those of you on our call that are not brokers, you should get your broker's license. I will help you do that. 40 years in the real estate industry, and of course, some of us today on the call have more years than I do. I didn't think anybody was alive before I was, but thank you all. I do teach continuing education for attorneys at UCSD, and I'm finishing off that class Saturday, I think is my last day after 20 plus years doing that. And I taught property management at the college level for many years, so we're going to be talking from a higher level here. And obviously on the right-hand side of the page there, risk management's my game. I believe in practicing risk management rather than damage control. I think that I'd rather figure out the problem before it becomes one. Let's take care of it. And I am happy to help you in any way that I can. So that being said, we're going to be talking about stuff today that's going to appear to be legal. I am not a practicing attorney. I can tell you that I have no intentions of that. In fact, I did a lot in law school, but I also cheated a little bit because I was in law school. You're only allowed to work 15 hours a week, and I was working probably 80, but you can figure how that works. I do a lot of trial work. I picked up another lawsuit today. My trial work is limited to testifying as an expert witness. Expert on the issue of standard of care for real estate licensees, as well as agents' duty of inspection and disclosure, and then finally market conditions in San Diego County. So our conversation is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Of course, if I am your broker, then you need to consult with me. And if you are the broker, you need to be talking to yourself, as we say. So that being said, talk today is intended to be interactive. Please ask questions or offer input by utilizing the Q&A button. And so I do look forward to hearing from you. And please make use of that. I'd rather make it go hot mic, but for a lot of reasons, we don't do that. Part of the problem is that an issue with the Zoom program is that if we go hot mic and you're able to say things and then you mute yourself later on, it just arbitrarily kicks you back in again for other reasons. And so we don't know why. It's just a problem with Zoom, and they haven't resolved that issue yet. So the Q&A button is going to be the best way to ask questions, and I'm happy to answer those as we go along. And so this morning we did our class on new and revised CAR forms. I had a ball with that. I hope you did too. I'm still responding to emails from that class, so I will get to it. I'll get to it before this evening. Now we're going to talk about leases and creating lease templates. So that's going to be fun. We're going to do a little bit of that. It's 2 o'clock in the afternoon. Apparently on Tuesday I have a break, but I haven't confirmed that yet. We'll be back on Thursday doing creating the ultimate listing agreement. If you watch for my newsletter tomorrow night, it'll tell you whether or not we're doing classes on Tuesday. So I had in my calendar that we were. And then on Thursday afternoon, the MLS CRS tax and finding pre-foreclosure properties. So today we're going to talk about member benefits, and I want to thank you for joining us for our discussion of residential leases and creating amazing lease templates. So I'm going to show you both how to do that, and some key concepts that we're going to talk about. Our subject matter today is residential leasing, not property management. So as always, some key concepts to keep in mind are going to be to always check with your broker ahead of time. Make sure whether you're doing leases or whether you're doing property management, make sure that your broker is aware of it. Make sure that they have errors and omissions coverage for it. Property management, by the way, has usually is a separate E&O policy. So they usually don't have coverage for it unless it's specifically asked for by the broker. So double check on that. So again, residential leasing, that means no interaction with the property. So today we're talking about leases, not property management. That means no interaction with the property after the tenant takes possession normally. And if once the keys are handed over to the tenant, the lessee, in commercial, we call the tenant the lessee. And we're still calling them tenant, even though we've changed the name of the landlord to rental property owner, RPO, because we thought that maybe the landlord term might have some derogatory connotations for people. So I'm sure at some point we'll change tenant into something different, but for the moment, that's what it is. So on the residential side, we call them tenant. On the commercial side, we call them lessee. But once you hand over the keys, it's over, right? Because you've delivered possession of the property. Keys constitute possession in California. So the leasing agent does not answer calls about repairs. In other words, once that's over, it's over. And so part of the problem that we see in our industry is where the agent was the leasing agent, and then they get involved in matters of discipline or guidance with the tenant later on in the transaction. So 3 months after the tenant moves in, the tenant doesn't pay the rent. The owner calls the leasing agent and says, will you send them out a 3-day notice to pay or quit? And that's what's going to trigger property management again. So it's anytime you access a form, anytime you send something, you do something in relation to the property after the lease has been put together and the tenant has moved in, anything you do after that is pretty much going to be outside of your contract with the owner. And we're going to see examples of that when we talk about when we're going to cut it off. But the anything you do after the contract has been what's the word I'm looking for? Linda, help me out here. Executed, fully executed, it will be legal advice. And so we don't want to be giving legal advice to people because you can only give them real estate advice based on a contract that you have with the person. So we'll talk about that. So obviously the water heater's busted. You're not going to respond to that. That's something that they need to take up with the owner, the rental property owner. You don't do repairs. And I find this happening a lot. As real estate agents, we tend to be, very helpful. We want to help people as best we can. But once we start doing things like that, then we're into the property management field. Okay, so you do not accept rent checks. I know that as been management of 3 of the largest brokerages in San Diego, and on very, very rare occasions, somebody would come into the office and say, I have my rent check. In which case we would throw them out of the office. We would tell them we can't take rents because we don't do property management. So again, check with your broker, make sure that your broker's position on this is fairly clear. So you do not provide forms. And by the way, that includes the pre-move out inspection statement, which happens 14 days prior to the termination of a lease. The tenant has a right to have the owner of the property or the property manager come in and go through the property and review it for anything that would possibly be a ding against their deposit. And so you may not provide those forms. Again, if you have a listing agreement that starts at that time, then yes, but otherwise you're doing property management. Okay, so clearly after the keys have been delivered, and we're going to talk about that, to either the lessor or the lessee. And so again, I want to, so all those things that we talked about that somebody could be doing, that somebody could be doing are the kinds of things that could end up making it casual property management. The Department of Real Estate is very clear. They call it casual property management. It is their term for someone who does not have a contract with the owner, who is out of contract with the owner, and who is helping the owner with the property. And I see it happen all the time where the agent says, "Well, I just gave him the form." Well, your name prints at the footer at the bottom of the page of the form, and so that's going to definitely get you into trouble. So we want to make sure that we're not doing that. Okay, so the California Department of Real Estate has a position on this, and as I said, it's their position that it's called casual property management when you're doing things essentially outside of contract with the property. So if you make a mistake, you may not have E&O coverage, and you want to be very clear with your broker what you're doing to make sure that you're not operating outside of your field of expertise. And so question, is there a difference if you are the owner of the property? No, if you're the owner of the property, you can do whatever you want. And that's a really good question, Joe. So if you're the owner, you can do whatever when you're an owner acting in a capacity not as a real estate agent. So if you're the owner of the property, you don't need to have a license to manage your property. That's okay. It's when you start using forms and things like that, then you're telling everybody I'm acting in my capacity as a real estate agent. That's when you're going to have a problem. I actually had that case. I had the case up in Riverside Court a couple of years ago where I was able to prove that the individual who was selling her home, she hired a real estate agent to sell her home. She happened to also have a real estate license, but she did nothing no forms, didn't do anything that required a license. So she was really just the owner of the property. And the lawsuit kind of hinged around that. And so I was able to prove in court that she hired an agent to do all the agent things. She didn't do any of the agent things. She didn't use her ZipForms program. She didn't do any of those things. And so I was able to prove that she was actually had no obligation to disclose a license status. It's a very, very rare interpretation of Civil Code 2079. And so again, in most cases, I tell people you need to disclose your license status, but if you're not conducting activities that require a license, you don't need to. So the question here is, if you're the owner of the property, you can either be an agent or not be an agent. That's really up to you. But when you start using the forms and stuff, and they've got the company's name on it and all those kinds of things, now you're acting in capacity as a real estate agent. So if you own several properties and manage them, and Joe, your question is a really good one. At one point I owned 40 homes, and most of them out of state, and maybe that was the reason I moved to California. It was a lot, but I was managing them myself, and I owned them myself, but I wasn't going to pay a property manager to do them because I felt like I had the ability to do that, and frankly I did have the ability to do that. And the laws in that state were also different. In that state, I did have a real estate license, but I still managed my own property, but they didn't distinguish the way California does about license status. So thank you. It's a really good question. Thank you, Joe. So as a general rule, doing real estate related activities on behalf of another in California, at least, requires a California real estate license. Is everybody okay with that? Just checking, making sure you can see it on the screen. Okay. Rental property owner and tenant relationships, and we're going to talk about some of that today. There has been a change in terms, as I said earlier. Instead of landlord, we're now calling the rental property owner. And of the 67 changes that occurred in our forms in June, on June the 27th at 1:30 in the afternoon, and I was hitting the refresh button. I was very excited about the new forms coming out, but the majority of those 67 form changes were landlord tenant forms, rental property owner forms, where we made these changes on those forms. And so property manager became the housing provider. The landlord became the rental property owner, because that would be their position. So so rental property owner tenant relationships, We're going to talk about the rights and responsibilities of the rental property owner. We're also going to talk about the rights and responsibilities of the tenant, and again, specific duties of the leasing agent. And again, quoting the California Department of Real Estate, which I love quoting them. I mean, they're pretty clear about, how they want things done. Here are some of the specific duties a leasing agent must perform. Again, not property manager, leasing agent. And so advise the rental property owner the rents that will bring the highest yield consistent with good economics, qualify and investigate a prospective tenant's credit, prepare and execute appropriate leases, advertise and publicize vacancies through selected media and broker lists, recommend alterations and modernization as the market dictates, inspect vacant space frequently, which I can tell you is rarely ever done. They really need to be up on that. I mean, you certainly don't want vandalism or things like that occurring in the property, or water leaks or things. Now, again, if you're a leasing agent, then your job is not to property manage, but your job, if you got there and you saw a water leak, reasonably, obviously, you would disconnect the water, but you would also contact the owner for repairing the property, because that's not your job. Keep abreast of the times and competitive market conditions, and that includes competitive market rates, right? Be knowledgeable about and comply with applicable federal, state, and local laws. And so, I bring that up, but the Department of Real Estate requires that all lease agreements prepared by a real estate licensee must be in writing, and that's what we call a statute of frauds. And so it's subject. So anything that we do must be in writing. The things that the public does don't necessarily have to be in writing. So if you're leasing out your own property, you don't have to have a written lease agreement. Again, I'm separating whether you're have a real estate license or not, but you don't have to have a written lease agreement. The reason why the statute of frauds is here is because the law says that an interest in land, in order to be enforceable, and that's the operative term, in order to be enforceable, must be in writing. So that's why we are required by law to have our agreements in writing. It's because we need to be creating enforceable agreements between the parties, and so the only way to really do that is to have it in writing. And so again, if Ma and Pa lease their property out to someone, and there's no real estate agent involved, and there becomes a dispute later, the court doesn't know what is it that you're asking us to enforce. And again, he said, she said, then now you're leaving it up to the guy or the gal in the black robe, which is that's I personally believe that if I have to go to court, and like I said, I just got another lawsuit today, but if I have to go to court, I'd like to have a document that I can use to say this is what we said, rather than me having to argue a position against a member of the public, who, by the way, has a greater chance of winning if I don't have my document in writing. Okay, so and I had a lot of attorneys coming into my property management classes, coming in and teaching, doing a guest speaker role, and I got interesting results from them. I always had an attorney, landlord's rights attorney, and then I'd have always a tenant's rights attorney, and so I just really enjoyed the difference of opinions that the attorneys would have, but I always had a pretty good idea what the courts were going to say. So that being said, again, the agreement clearly sets forth the responsibilities of both parties, and I think we're at a time today with the lease agreements and things like that we're more at parity than we've ever been. I think CAR's done a great job with our forms. So our leasing agent's liabilities. So such obligations include good faith and loyalty to the principal, performance of all duties with skill, care, and due diligence, full disclosure of all pertinent facts, obviously, avoidance of commingling of funds. So again, if you're doing a lease, and the tenant sends you a deposit check, and again, currently our contracts say no check. But if you were to take that deposit check and you were to put it into your bank account,
then that's going to be commingling the funds of others along with your personal funds. So you don't ever want to do that. That is clearly a license losing opportunity. We had an agent with a company where I was management, and the agent had the owner pay the commission check to the agent directly, which, as you can imagine, is a violation on a number of different levels. And of course, we found out about it as a brokerage, not the current brokerage. This was a company I was management for, and we found out because the tenant called us up and said, we're having problems with the property. We can't get, your agent to respond to our call. And we're like, well, we don't do property management. And so but the situation unraveled to where we found out that our agent had leased the property without telling us about it, and then had the check cut to them directly on the commission. And so, needless to say, that was an item that we had to report to the Department of Real Estate, and we had to terminate the agent. So don't be, you need to let your broker know everything that you're doing. It's really, really important. And I always say in our brokerage firm, listen, we want to hear from you. It's the people that we don't hear from are the ones that make us nervous, right? So please, make sure your broker's aware of what you're doing. Refraining from personal profit. And so I want to distinguish that because obviously we're in this business to make a profit, but sometimes agents will do leases and they'll do things. They'll say like, well, don't worry about it. I'll just give you the forms, and it's too much trouble for me, and that kind of thing. And even if you don't collect a commission, that does not change your liability. If you are doing a transaction on someone's behalf, be upfront, be completely on the table about it. But if you're getting a check, so for example, in that scenario where we had to terminate the agent, again, it was for a $500 commission check. It wasn't, why would you risk your license for any amount? And then again, doing a transaction and not getting paid does not decrease your liability. The court system says there is no minimum, there is no maximum commission. So your liability is just by doing the transaction or helping them and providing forms or doing things like that. It has nothing to do with whether or not you're compensated. Again, no minimum, no maximum. You could go for zero. It's okay. But the court is still going to hold you liable for the work that you did. Some MLSs across the country have changed their rules, by the way, to where they're allowing zero to be the compensation to the buyer's broker. And so, and the idea being that they were, doing, 1 penny, but then they realized that is a minimum. And so they had to get rid of the minimum because they can't take a position on minimum or maximum. So they have to allow zero. And so that's one of the reasons I tell you that we're going to see these buyer representation agreements take foothold. I suspect that January 1st, we're going to introduce legislation that is going to require the buyer representation agreement. So, and you can have a buyer representation agreement with your tenant as well. That BRBC form is also, you can also use that in looking for properties for a tenant. So again, I encourage you to have that. It is coming to a theater near you. I know in our office we use them. This is the only way we do business. We don't pay our agents without it. So you pretty much have to have one. So the agent must be familiar with the laws concerning real estate licensing, contracts, agency, fair housing, property protection, insurance, and a tenant landlord relationship. And so fair housing, I'm going to say also ethics, right? But again, these are all the things that you already do. So they're already the things that you're required to know to do a real estate transaction. So there are going to be some significant leasing laws that we're going to talk about. We're going to talk about the types of laws. They're changing all the time. San Diego County has their own in addition to the state laws. New restrictions on evictions, by the way, as of the 27th of May of this year. So make sure that you're familiar with those. If you're doing, you would not be, except as a property manager, you would not be involved in an eviction because that would be legal advice, clearly. So we wouldn't want to do that. So we'll talk about the implications of those things. You could risk loss of license, sanctions against your license. Under fair housing, it's a possible federal offense. So obviously a crime to commit a fair housing violation. California, again, has 22 protected classes. And the 22nd one is any arbitrary characteristic, which means anything that doesn't fall in the first 21 may fall in number 22. So therefore, if it becomes a crime, a federal offense, then criminal sanctions and probably no E&O coverage. So anytime you break the law, your E&O policies don't cover you for breaking the law. They're not going to cover you for that. And then obviously loss of license. And so I do want to talk about tenant selection before we get into the forms. But screening, for example, you got to be careful with screening. So it's best not to require a photo ID until after the decision has been made to lease. And I was on a fairly high level call with CAR last week. And I remember Gov Hutchinson was on the call. He's one of our attorneys at CAR, and I had made a comment to him in the risk management meeting last year. And I said at some point we're going to stop putting their names on the contracts because it could be a potential violation. And he got a chuckle out of it, and so did everybody else in the room. But you know why? Well, because some names, you know, people might be able to equate nationality with them or whatever. And so it is not going to go to that, but you know, at some point you need to know who you're dealing with. But again, potential fair housing violations from that photo ID. I mean, you could see, you know, what race I was or what nationality or whatever, and so that could also create some problems. So my advice with the decision to rent to someone should be made prior to getting a copy of the photo ID. You want the photo ID in the file, but the timing of getting it is important. So remember that all tenant applicants complete the same application. So again, fair housing, all the applicants get the same form. You can't provide one form for one and no form for the other at all, or a different form for someone else. You don't want to be doing that. You want everything to be, again, a good case for why we use templates is because we want to do the same thing again and again and again with everyone and treat everybody equally and everybody fairly, okay? So separate application, excuse me, separate application forms for each applicant. Let's talk about credit reports for a minute. It is a criminal offense, a federal offense, to pull someone's credit, to run their credit without their express written prior authorization. So we're going to talk about the LRA form. That's the lease rental application screening report form that gives us the authorization to pull someone's credit. In our office, we don't even pull it anymore. What we do is we have them use SDAR has a great service with TransUnion. It's called Smart Union. And so My Smart Move, it's called. We use that. We just send the tenants straight to that. They do all of their social security number and everything else with that organization. And that's how we find out from that reporting agency, you know, the risk that is possible with that particular tenant. So we have all that. They pay the service. They don't pay us anymore. We still have the application, but we don't have. They're going to get their credit report run and all that on their own prior to selection as to whether or not they're going to be the accepted tenant. So you must have a separate credit report for each applicant. Some of you will remember the day not that long ago, really, where you know, we would have the husband come in and they would fill out an application, do the credit report and all that, but then they would move the wife in later without having all this stuff done. And so one of the reasons why we want to standardize all this and do the same thing for everyone is because, you know, sure enough, I've had that happen and I've said, no, she can't stay because she's not on the application. I need her on the application. I need her credit report. Well, she has really bad credit. Well, okay, I get it, but you know, we need to know, you know what that is. is, we make our decision on whether to take someone not just on their credit report. I did have an individual come into the office. He had 16 pages of bad news. It was husband and wife. They just had, I've just never seen a credit report quite that bad. And I'm going through files right now. If I find that, I'm going to save it, but although I can't really publish it. But anyway, I told him, I said, you should have this bronzed. I mean, it was an amazingly bad credit report. And they came into the office and they sat down with me for 4 hours and they explained every single item on their credit report. And, I took them as a tenant. So the credit report really just shows a propensity to pay something. I've had, they ended up being one of my best tenants ever. And in fact, they referred business to me because nobody else would take them. And I said, no, I'll take it. That's fine. But the credit report was horrible. But it turned out there was an easy explanation for it. They were coming from a town, a small town up near Santa Barbara that their family owned pretty much the whole town. They didn't want these two getting married. It was kind of a Romeo and Juliet story. And when they did go ahead and get married anyway, the family just proceeded to have their credit trashed. And so, which was really a shame. I mean, it says a lot, right? But these tenants turned out to be great tenants. Rent was on time all the time. Really, really great. I had another college kids from 4 girls and a guy from UCSD, and they said nobody will rent to us because we're students. And so we took a look at them, and we took them as a tenant. And they, again, probably there were 4 girls and a guy, and it was a 4-bedroom house. So we said, which one of you is cohabitating? And at one point, I guess one of them was sleeping outside of a window of one of the rooms. But interestingly enough, they after they moved in, they went around the neighborhood. They made cookies for the neighborhood, and so they went around the neighborhood and they introduced themselves to the owners or the tenants and other properties in the neighborhood. It was on a street called Ambervale Terrace in Carmel Valley, and we owned the property, and they went around the neighborhood and they said, here, have a cookie. And oh, by the way, if we ever do anything that upsets you, would you please let us know? We don't want to have to talk to Mr. Burke again. So, we had a great relationship. It's just they didn't want to have to deal with me again. And so, that's why I believe in setting boundaries. It's a lot like working with children sometimes. You're going to set boundaries. And so they were great tenants, never had a problem with them. They were awesome. And in fact, when the lease came up for renewal after a year, they were leaving anyway because they were all graduating from, they were graduate students at UCSD. And so we offered to reduce the rent just to keep them, but they elected not to stay, because they were all going to the 4 or the 5 wins, I guess you would say. And then interestingly enough, the tenant we had after them was a heart surgeon from the VA hospital, and he and I just locked horns from the very beginning, and we sold the property with him in it, but boy, he did everything he could to keep that from happening. And so bottom line was, just because they have a great credit report doesn't mean they're going to be a great tenant. They could have a lousy credit report and be a great tenant. I mean, there's a lot of things, and good tenants go bad, and rarely do bad tenants. Bad tenants usually start out being good, but you check landlord references and things like that. So again, separate credit report, separate application. Everybody over the age of 18, which we call the age of consent or majority, who's going to live in the property for more than 14 days. And the reason for that is that the law distinguishes between a guest and an invitee. And so different laws impact them. If they're not on the application, if they're not on the lease agreement, then they're handled differently and they're more difficult to get rid of. If they're on the lease agreement, then the rules apply to them. So it's really, really important, everybody, make sure you got everybody on the lease agreement. So I have always said, if you want to understand real estate, the forms will teach you. I think the forms talk to you. So we're going to hit the big ones here in just a minute. So on the leasing side or on rental agreements, think of it as a tree. All forms flow from either of these 2 choices. Okay, so leasing or rental agreements, so the listing side versus the leasing side. side. On the listing side, we've got the lease listing agreement. That's CAR form LL. We're going to go in there. We're going to kill it in a minute. So let's go ahead. Let's go take a look. Okay. So taking us back over, I'm going to take us back to our list. So these are my templates. They're found up here under templates, forms and checklists. These are the templates. And so we do everything based on template. Again, like I said earlier, because we want to protect ourselves, we want to treat everybody equally. We want to treat everybody fairly, so everybody gets the same thing. So this morning I did CAR new and revised forms, and now we're going to talk about the lease template, which I've combined, by the way, for both the listing and the leasing side of it. But I'm going to show you that in a minute. But the point I'm trying to make here is all of these, our office is template driven. We create all these templates so that, when we do a transaction, again, most real estate, most of your stuff is the same stuff again and again and again, right? I mean, there'll be some diversions like that. The buyer has to sell to buy or something like that. But I'm going to treat everything essentially the same. So I'm going to click on my, and the reason again that I use the template version here is because when I use the template version, CAR is going to update the forms for me. Okay, so let's go ahead. I'm going to click on Lease Template. And I see when I open this that I have a listing side and I have a leasing side. And then notice that I also have environmental booklets. So when we do a real estate transaction for a sale, the law requires for both sales and rentals that we provide the environmental hazards booklets and all the disclosures that go along with that. And it's a fairly extensive library. And again, the law requires this. But we don't have the access to things like the natural hazard disclosure. Some of the natural hazard disclosure companies, and we use a very specific company, which again, I'll help you offline if you want, send me an email. But we use a specific natural hazard company that also includes in their reports the environmental hazards booklets. But not all natural hazard companies do that. And again, remember, the law requires it. So I'm just waiting for the Department of Real Estate to start going after people for, not providing the environmental hazards booklet, which is again required by law, health and safety code, et cetera, et cetera. But it's a very commonly missed thing on a lease, in a lease, because there is no natural hazard disclosure necessarily. So let's go ahead in here. I'm going to click on in my template again. I'm going to click on the listing. And so we're going to let's talk about the lease listing agreement first. And so I want to talk about that. I'm going to click on that. I'm going to open it up. Hopefully, can you see? Yes, you can see all that. I go to big screen. Yes, you've got big screen. So this is my lease listing agreement, otherwise known as my CAR form LL. Again, why do I use the template? Because CAR will update my templates with the current forms. They will update the forms in the template with the current form. So here I've got my 6/23 date because we updated this form. If you didn't have it in a template and you were just copying transactions, you're probably using an old form. And so you're definitely out of compliance on a number of different levels. Okay, so that being said, just going through here fairly quickly, the date prepared, obviously, the name of the owner of the property, whatever that is, and again, their name as it appears on title. So we always look that up. Linda always pulls the grant deed. She knows exactly how they own the property because we want to make sure that we actually have an agreement with the owner of the property rather than somebody who says that they're the owner of the property. So we look at the title to make that determination. We have to have a beginning and an ending date. The law requires that. The Department of Real Estate, if they do a review of your file, they're going to be looking for both. And I have done reviews of transaction files prior to a DRE audit, and I have found listing agreements that aren't completed properly. They don't have a beginning and or an ending date. And when I've asked the broker why not, they say, well, we want to be able to change it as we go. The problem with that now is that, and the DRE catches this for sure, the problem with that is that means that you're changing the date over a signature, which means that you are committing fraud. So you never alter a document over a signature without getting everybody's initials and things like that. So I would advise against that. So this is the exclusive and irrevocable right. So just like my exclusive listing agreement, to do this. My terms, I'm going to put in whatever the rent amount is going to be. In the forms of dollars and under what period. So the rents are typically, let's say, $1,000 per month. So again, this is the listing agreement. Now notice, folks, that this is the very first form. You notice that the agency disclosure is not in here. And the reason for that is that the law says you don't need to disclose agency. I think you need to, but you don't need to disclose agency unless the agreement is for greater than a year. So so again, let's take a look at my agency disclosure form, which I always tell you is the very first form you ever have a client sign. I have checked the box that says it's being used in connection with a transaction for a leasehold interest exceeding a year per the civil code. So this is just a standard agency disclosure form, and we're going to check the box. We're going to do this in every transaction that we do anyway. The law requires that we disclose the concept of agency prior to committing conduct that constitutes agency. So we're going to do it even though the law doesn't require it if the leasehold interest is for less than a year. Everybody good with that? Now I lost it. Here's my listing agreement. Okay, so back to my listing agreement really quick. We're going to go paragraph number 2. What is the rent amount again? Paragraph number 2B. What is the security deposit? You have to put that number in there. What kind of tenancy are you contemplating? So is it going to be a month to month? Is it a year? Most real estate agents like to do a year. And part of the reason behind that is that they get paid basically, most that I'm aware of get paid based on gross rents, but you can also charge, we'll talk about commissions in a minute, but that's why I tend to see most of them being for a year, but you can do a month to month. The seller, the rental property owner can say, I want a month to month tenancy. But the reason that most agents would prefer a year is that now they've got to go, chase them for the, monthly if that's how they're getting paid. But we're going to talk about that compensation, whatever that looks like, in a minute. Items included in the lease rental, all fixtures and fittings, obviously, and maybe the following items of personal property. So I frequently see refrigerator, washer, dryer put in there, although it could be even more than that. I'm going to give a list of what's going to be in there. That's probably how I would handle it. Personal property that will not be maintained or replaced by the RPO, and that's where we would put that. That obviously the owner is providing it as an accommodation only, but they're not warranted in any way, and they're not going to fix it. So again, if you don't put anything in here, folks, you're going to eat it. All right. So again, we need to make sure we fill in all of our forms. I have a dispute right now where the company did not include all of the information on the form. And now, of course, everybody's fighting over it, and it could end up in a legal situation. I'm doubting it, but that's the way it is. Items excluded from the lease rental, maybe the garage and carport. I mean, I had a property at 280 Surfview Court that I handled for many years in Del Mar, oceanfront. The owner would visit it occasionally during the year, and we were leasing it as a short-term rental, and he refused to let the tenants have access to the garage. So he had his BMW, the big BMW in there, and he had all this personal stuff in the garage. He even had some closets that had his clothing in them, but that he still, because when he came into town, he didn't want to bring a suitcase. So the tenants were always kind of working around that. So, but again, that's going to be items included or excluded from the lease. And then any other additional terms, and there's your opportunity to give legal advice. Be careful what you write under additional terms. Then we have our compensation. So the amount or rate of real estate commission is not fixed by law. The DRE requires us to have that language in all of our compensation agreements, all of our listing agreements. But remember, your buyer representation agreement is a listing agreement as well. It's a listing of the buyer. They're set by each broker individually, and I always love may be negotiable. Of course, I very rarely have a problem with my commissions. I never have anybody question them because of the way I present my listing agreement. May be negotiable between the RPO and the broker. By the way, negotiable doesn't necessarily mean down. I mean, it can also mean up. And so I usually threaten them at the table, and they usually go, okay, I don't want to mess with that. But so I usually get away with it. Commissions include all compensation and fees to the broker. So again, if you have a fee you're going to charge this individual or this corporation or whatever this is, then that's going to be considered a commission. Okay. The reason for that is the Department of Real Estate, they don't care what you call it. They're going to call it a commission, and they're going to establish rules for commissions. And so no matter what it is that you accept in a real estate transaction, they're going to treat it like a commission. That's what that means. Again, paragraph number 3A, agreement to pay irrespective of agency relationships, because at the time of taking the listing, we don't know if you're going to be a single agent or a dual agent. So when you take the listing, you know for sure you're a single agent, but if you represent the tenant on the property, now you become a dual agent. So regardless of whether you're single or dual agent, that's what this means, irrespective of agency relationships specified as below. So again, for fixed term lease, this is our template. So I've got the figures in here that we charge. You charge whatever. Your broker has an obligation to create a minimum commission split or commission charge fee in your office policy manual, et cetera. So make sure you're following your broker's advice. And again, you can have either a percentage of total rents, or you could have a dollar figure or whatever else. I mean, you again check with your broker as to what you're able to charge. And then under 3A1B, you could charge additional sums, but again, you have to tell them what that's going to be. Okay. So again, payments due by default upon extensions or renewals, that kind of thing. And then under 3A2, we have the itinerant rental, the month-to-month rental, the short-term rental, which again, you're going to define what that is. So in our case, anything short of 6 months, we're going to call it a month-to-month. Anything longer than 6 months, we're going to call it a lease, right? So okay, and then under 3A3, for either a fixed term or a month-to-month, if during the period of time that we procure a buyer or a tenant for the property on terms acceptable to the owner, then they agree to compensate us. Okay. All right. And then 3B is the safety or protection clause. This is the clause that protects the real estate broker from the parties, the buyer, the tenant, and the owner, the rental property owner, from creating a lease after the expiration of the listing agreement. And I've had that attempted at brokerages where I was. We've never had it happen in our brokerage, but in some brokerages where they say, let's just get together after it expiring on Friday. We'll get together on Saturday and we'll create our own agreement. And of course, I don't think that's wise for anybody. That's why licensing activities is regulated by the state of California. But we put in ours 90 days. You put in whatever, so that's called the safety clause or the protection clause. It was actually a test question on the state exam when you got your license. So, and then finally down here, one of my favorite things, if without the broker's prior written consent, the premises are withdrawn from lease or rental, are leased, rented, or otherwise transferred or made unmarketable by a voluntary act of the RPO during the listing period or any extension, you're going to owe a commission. Okay, so they say a voluntary act. I mean, if the place burns down, obviously that's not a voluntary act unless it was arson. But if they do something to prevent you from your job description here, then they're going to be owing a commission. Okay, so if commencement of the lease or rental is prevented by a party to the transaction other than the rental property owner, and then the owner prevails in a lawsuit, then we are entitled, much like the listing agreement on a property for sale, an amount equal to the lesser of 1/2 of the damages recovered or the above, after deducting the expenses, if any. Okay, all right. So a lesser amount of either half of the damages or the above compensation. Okay, so again, like I always say, don't leave a blank. In addition, the RPO agrees to pay, and we don't charge any extra fees. I have seen extra fees charged. I ended up becoming a co-listing agent on a property up on Paint Mountain, where the original listing agent had a signed listing agreement with the owner of the property for a lesser commission. However, the owner agreed to pay $5,000 a month towards marketing the property. So they put the $5,000 in here towards marketing the property, et cetera, et cetera. And they did. They monthly paid a fee to them to do that. It was a very expensive home at the time. But you know, if you're going to collect a fee, it has to be in paragraph number 3. That's a rule. All of the fees that you collect must be included next to this language right here. Is everybody okay with that? All right, let me see here. Anything else? Compensation on subsequent sale. We talked about this in this morning's class. So we expect to be compensated if the RPO agrees, if the tenant directly or indirectly acquires the property. Okay, so we expect to be compensated for the sale. Okay, page 2. We also agree to compensate. We share compensation with other brokers. It's not necessarily an equal amount. I used it as an example here where we were charging 6% for the lease, but we're only paying out 2.5%. And I see this is very, you know, the point I'm trying to make is there's no rule that says that you have to compensate equally, that there's no rule that says you have to split commissions. It's whatever you tell the owner. You have to tell the owner, this is how much money I'm going to pay the cooperating broker. So again, I've seen this go the other way. I've seen people say, you know, I'm going to pay, you know, 3% to the other side. I'm only going to do my side for 1%. But whatever those numbers are, that's what you put into the agreement, and that's what needs to go into the multiple listing service. Okay, so and that's true for both the fixed term lease or the month-to-month rental. And let's see, G is important. RPO warrants that the RPO has no obligation to pay any other brokers. So we have to ask the question because the public, supposedly the innocent owner, isn't aware of the fact that, you know, they could end up signing listing agreements with more than one broker. Therefore, they would be obligated to pay more than one commission and have more than one broker represent them. So we have to tell them that. We have to ask them. We say, you know, do you have an agreement to pay any other broker? And if the answer is no, then replace, you know, NA may be the answer. Okay. All right. And again, we do the disclaimer for you. If the premises are leased to anyone listed in 3G1, the RPO is obligated to pay another broker. Broker's not entitled to compensation under this agreement, and the broker's not obligated to represent the RPO with respect to such transaction because you've got an obligation to pay somebody else. So we have to say that, and we did that really to protect the brokerage from getting into a lawsuit because of course, the owner always says, "Well, I didn't know." Okay, tenant payments by default, everything goes to the owner. Again, this is a lease. If you are having monies come to you, then there's a potential that you could be property management. But also, we've just gotten to a point where we don't take checks from tenants or from owners or from buyers. So we would just assume that they all go to the RPO. We invoice the RPO and charge them that way, and we've never had a problem with it, although I imagine that there are people that would have a problem. Direct electronic payments, I'm not a fan of that. I will tell you from a personal standpoint, we had a tenant try to Zelle payments to us, and of course, and this was what was the rent? Was this like $34.95? And so their first attempt at a Zelle payment, we got $100. And so we don't know, to this day, we don't know why. We've just decided we don't do electronic payments anymore. But if the owner wants to do electronic payments, then they need to speak specifically with a landlord tenant attorney, what we call a QCREA in California, qualified real estate attorney, because you have some issues with evictions, you have some issues with NSF checks that we'll talk about in a minute. Key safe lockbox, we want to be able to put a lockbox on the property. We have to have the tenant's permission to do that. That's included in the KLA form. We want to have a sign up there. The default language says that there's no sign going to go up unless we check the box. So I think it should be the other way around, but it's the way that we're doing it. We also tell the owner that we're putting the property in the multiple listing service, and we have an obligation to comply with that. Again, subject to clear cooperation, like coming soons and things like that. Security and insurance, we don't have insurance for your stuff. We tell the owner that in the agreement. The owner tells us in 9 that they actually have the authority to lease the property and sign leases and sign this listing agreement. And if someone else has that right, then let me know who that is. Then we talk about representations, that the property is current on financing. There's no NOD's been filed, no litigation, no stuff like that. We also have to tell the owner that if they are, this is one of the reasons why we stopped allowing the short-term forms like the vacation rental forms and things like that, because we were getting into a problem area. We added language to the lease that says that we have an obligation to report if the owner of the property is not a California resident or a corporation or LLC qualified to do business in California, then we have an obligation to withhold funds, 7% of the gross payments to the RPO that exceed $1,500 in a calendar year, unless they give us the 589 or the 588 form. So, we really don't want to be in a position of having to withhold money from the seller's proceeds. That's really a property manager's job. So we added that language in there, and we're hoping, we've never had a problem with it, but we're hoping that we don't. So on the state level, it's 7% of the gross payments. On the national level, it's 30% of the gross payments. And again, we have other forms for them to provide if they want to avoid that. But we tell them in 11C that we have a legal duty to report rental income that is received to tax collection agencies. Again, another reason why we don't want the money. Okay. And then we talk about the brokers and the RPO's duties. I don't want to run out of time here, but we as the broker agree to exercise reasonable effort and due diligence in the performance of the agreement. The RPO agrees to complete the RPOD because we're going to give that RPOD to the tenant. There were a lot of disclosures that were not being made on a rental that were statutory disclosures. For example, death on the property is required that we make that disclosure. We're going to go over that form here in a minute. You can see this is a pretty long form, but we're going to cover most of the forms that we're going to need in a rental right here with these attachments. So we want it within 3 days of completing the agreement, and they authorize us to give it to the tenant. It used to be the other way around. This used to have the RPOQ attached to it. But then we created the RPOD, and then we switched the terms, and long story, don't worry about it. We just want to make sure the disclosures are made by the owner to the tenant, not by us. Let's see, the RPO agrees to consider offers, et cetera, et cetera, et cetera. So, but also the RPO agrees to indemnify, defend, and hold harmless. We love that language, right? For misrepresentations made by the RPO or any material facts that they don't disclose, things like that, or cause of action by the Department of Fair Employment and Housing, things like that. So we want to make sure that we have some indemnification from the owner of the property. Agency relationships, again, we talk about the disclosure form. We talk about representation, possible dual agency with a tenant, other rental property owners. That's our disclosure and consent form, right? Remember the PRBS form? We're going to represent other owners in the area. Confirmation of agency, again, required by law in 1 to 4 units. That's Civil Code 1102. So termination of agency relationships. So this is the part I wanted to bring up. So when do we become a property manager when we really were just being a leasing agent? And so we didn't have this in the previous forms, and so I like this language: termination of the agency relationship. So the RPO acknowledges and agrees that unless we enter into a separate property management agreement, the broker will not represent the RPO in any manner regarding the management of the premises. We want to put this out on the table. RPO further agrees the representation duties of an agency relationship. Agency relationship terminate at the earlier of what? And so of 1 or 2, or little I or little II, either entering into a rental or lease agreement would terminate it, or if checked, and then now we're going to check all that apply, the tenant occupies the property. We believe that we give the tenant the keys. So we never give the keys to the tenant prior to the lease beginning. So that's our way of doing it, is once we give them the keys, we're out of it. Tenant does a walkthrough. There can be a lot of different things that you do. We don't have a MIMO form anymore. They still have that in the contract. So I'm going to make a note of that and have them fix that. But we don't have a move in, move out anymore. Now we have a separate move in and a separate move out. Okay, attorney's fees, and this is a new one, and I personally like this. So in an action, a proceeding, or an arbitration between the owner and the broker, everybody pays responsible for paying their own attorney's fees and costs. Okay, so that's a big departure from, prevailing party gets their fees paid, and this is intended to discourage lawsuits, and it's in pretty much most all of our forms now. So we're just trying to discourage litigation. Dispute resolution, mediation is always first. And again, I'm not going to explain all these clauses and all the forms. We're just going to cover them all here. So, but if you commence an action without first attempting to resolve it through mediation, or before commencement of an action refuse to mediate after the request has been made, then, and that party is the losing party, then the prevailing party then shall be entitled to recover attorney's fees. So you definitely want to agree to mediation's default in all of our contracts, and arbitration, we'll talk about arbitration in a minute. But additional mediation terms, obviously a judicial or non-judicial foreclosure, we're not going to be involved in that. Any manner within the jurisdiction of probate, small claims, or bankruptcy court, we're not going to be involved in that. Not subject to mediation. Filing of a court action, recording notice of pending action, that's called a lis pendens. Any of those kinds of things don't constitute a waiver or violation of the mediation provisions. Paragraph number 15C talks about my arbitration provision. So we took the arbitration clause out of all of the listing agreements. They're still in the agreements between the parties, the buyer, the seller, the landlord, the tenant, the RPO, the tenant. But we took them out of our listing agreements. And the reason was because brokers were saying, no, we'd really rather go to court. We don't want to take the chance that one individual in an arbitration hearing gets to make the decision without, you have due process, but the arbitration is not appealable. Under very rare circumstances, if there's an error of law, but the brokers were all said, no, we don't want to be subject to that. We want to go to court. And so that's why they made arbitration at the discretion of the broker. So the agent was committing the broker to arbitrate when they signed the agreement with the owner, and we wanted to make that go away. We wanted to make it something that the broker had to approve. Management approval. So if an associate enters into the agreement on the broker's behalf and the broker manager does not approve of it, the broker manager has the right to cancel the agreement in writing within 5 calendar days after its execution. And that's a DRE. That's right in the DRE regulation. So that's why the DRE says that you as an agent or an associate have 3 days from getting a signature, anything material to a transaction, getting it to the broker. So you have to provide all this stuff to the broker within 3 days, which gives them 2 more days to decide if they want to take it or not. I rarely ever see it done. I always had people walk into my office when I was representing other brokerages They would walk into my office and they would say, here's the file. And I go, what's that? And they go, well, it's closing. And I go, when? They say it's closing on Friday. And I say, you're supposed to give that to me within 72 hours of the transaction getting put together. And certainly any material facts had to be, but you're not getting paid on Friday because, you know, I haven't had a chance to review it. It's already too late for me to cancel the agreement with the owner if you did a bad thing in there, if you follow my drift. So again, that's the law. Some brokerages, so your agreement with your broker can be for less time, but it can't be for more time because the DRE says you have 72 hours. So in our office, 24 hours, although our agents are really good. They give us everything, you know, immediately. So, which is the best way to do it. Equal housing opportunity, additional terms. So we have the RPOD, the RPOQ, we have the Fair Housing Discrimination Advisory, we have the CCPA, which was updated again just recently. And then we've checked agency disclosure because we want that in all of our transactions, whether it's exceeds a year or not. And then the KLA, we're going to have that always as well. Successors and assigns, that just means that the agreement is binding upon the RPO's successor and assigns. By law, it's considered a personal services contract. So if we pass away, there are no successors or assigns, right? So you got to get a whole new listing agreement signed by everybody. Time of essence, entire contract and changes are all included. Legally authorized signer. So we've added the RCSD equivalent into this document, which we've had before in the purchase agreements. I really like this. If you complete this properly, and I did have a misunderstanding with another brokerage firm the other day. We had completed the form, we had checked it for the owner, we had checked the form, filled it all out. We were in complete compliance. And they claimed that they talked to the legal hotline, and I was surprised legal hotline didn't call me, but they obviously didn't tell them who they were dealing with. But anyway, make sure that you fill in all the, if you check this box, then these fields become fillable fields. So again, when you put in the owner of the property, you put in their name, legal name as it appears on title, but then the signing authority may be somebody different. Somebody has to sign on behalf of an entity. Entities can't sign on their own behalf. So if you look down here, printed name of legally authorized signer, when I check that box, then it becomes, it's checked down here as well. And I put the name of that one or two people up here who have the authority to sign on behalf of the entity. Okay, so make sure that their name appears in here. The printed name of the rental property owner would be the owner, the trust, the corporation, whatever. But the printed name of the legally authorized signer would go in here. Their title would go in here, and then they would sign the documents. Now, you know, interestingly enough, we learned something in that process. So when I look up here where it says parties, I click on parties. In here, obviously, we don't have any parties other than myself. But when I do the sell side and I want to put the landlord number one, if the landlord is an entity, then I'm going to fill in the name of the entity under last name. So this is important. Under last name, don't put an email address. If they have a signing representative, then you put that information in down here. Okay, and so you put the first name, middle name, last name, whatever, the email address of the signing authority, the person who has the power to sign on behalf of that entity. Okay, so the last name field will be their name as it appears on title, and then down here if they have an individual signing. So this is going to be the majority of your transactions, right? Because you know we have more than half of our real estate is owned by trust nowadays. Okay, all right. So I wanted to show that to you. Let's go back to my document. Where did it go? Here we go, lease listing agreement, and we'll make our way back down through here. I wanted to show you that while it was fresh, while we were talking about it. Again, we'll put the rental property owner's information in there. I'm going to uncheck the box because we don't know what we're going to end up with. And again, we use this as our template. Then we have the company's information. Again, in our office, we create their agreements for them. So I would just replace their name, you know, my name with their name. I would put their name in there. I've got a couple of these waiting for me after I get out of the class new listing agreements with people. So we'll fill that out. And here's my rental property owner disclosure. Again, intended to look very much like the SPQ, because there are some disclosures, like lead-based paint is a statutory disclosure that a lot of real estate agents weren't aware of it even. But if the property is built pre-78, then it very clearly applies to that this transaction. So we're going to have that lead-based paint, those questions being done. If it was built pre-78, that means we have to use the lead paint addendum, but you still must make disclosure of lead in your home, whether it was built pre-78 or not. And that, again, is under my environmental forms. Okay, so I don't want to spend a lot of time on this because I really got to get us moving. Mold, asbestos, all military ordinance is a statutory disclosure. Death on the premises, again, Civil Code 1710B, within the last 3 years. If yes, does the RPO know the manner of death? If yes to one, that's the manner of death. Could be a material fact to a tenant, should be disclosed, except for death. There's no obligation at law to disclose death by HIV or AIDS. And so if they say, what do they die of? And you say, I don't have to tell you, then now you know that it was HIV or AIDS. Other material facts, if any. And again, this form is very, very important. I'm kind of really glad we have that. So this is the RPOD. So again, when I go up to the top of the form, it tells me who does this go to. It's to be with a lease listing or property management agreement and with the lease. So the RPOD, once completed by the owner now, again, you must not complete this. These are all gray fields, means that the owner has to do that when you send it to them, the electronic signature. But the RPOQ is a form not to be used with a residential lease. And so it may look like the questions are the same, but they aren't. And obviously they're in different orders and things like that. Again, the owner is going to have to fill in all these forms. Okay. All right. What else? My fair housing and discrimination advisory, I think it should be up towards the top. But again, it was revised fairly recently, 6/23. Most of the changes were just changing landlord to housing provider. So here's my any arbitrary characteristic is number 22. Okay, get through that. The CCPA was updated in December, and that will round out the form. Woof, that was a lot. So again, that was my lease listing agreement. We covered a lot of these other forms in that. There's my lead-based paint. So again, and then the rent cap and just cause is going to come up now when we go to look at our lease agreement. Okay, so we're going to pull up the lease packet and we're going to look at the residential lease or month-to-month agreement. So let's do this one really quick. And again, I'm going to show you how to create templates on your own here. It won't really take us very long, but here's my lease or month-to-month rental agreement. We changed the name. It used to be the LR, but now it's the RLMM because it's a rental or month-to-month, rental lease or month-to-month. So again, this is with the tenant. Now the tenant and the owner of the property, the RPO. So we put their names in here respectively. The property, we want to know the address of the property. We want to name the persons that are going to occupy the property. So obviously if they have children, you could put them on there. You really can't prohibit them from having children. So, but once the child reaches the age of consent, 18 or older, then we're going to want them to sign the lease agreement. But prior to that, they don't have capacity to contract anyway. It would be voidable at their discretion. So, but all adults over the age of 18 that are going to occupy the property, again, here says it right down here, any person in the premises. So any person in the premises other than those listed in this paragraph are considered a guest. Guests are not permitted to stay more than 14 days. Otherwise they're not a guest, they're an invitee. And so again, without the housing provider's written consent. So again, very, very important. Everybody that's going to live in the place needs to be on the lease agreement. Everybody that's going to live in the place that has to fill out an application. You must run the credit on everybody. Don't just run credit on one. You got to run, if you're going to treat one, you got to treat them all the same way. Okay, so that's an important point. Personal property, again, could be an attachment. Is the property subject to local rent control ordinance, not state, but local rent control? What's my beginning date? We're going to talk about that being the commencement date. And then we're going to decide after that whether or not it's going to be a month-to-month or a lease, something we talked about earlier with the other agreement. Okay, so and then shall terminate. We have it terminate at 5 o'clock on at the end of the whatever the termination date is going to be. Rent, again, tenant agrees to pay a certain amount of money per month. Now, remember that when they're signing a lease, a year's lease agreement, they've agreed, and let's say it's $1,000 a month, they've agreed to pay $12,000. So this is why when they're accepting rents in monthly increments, it's an accommodation to the tenant. So the owner is accommodating the tenant, having them pay monthly rather than the whole thing up front. So this is why 3 months into the lease, they decide they're going to break it. They owe the 9 months that's remaining on the lease agreement. So this is a concept that gets lost on some, but again, they owe the other 9 months. Now, the owner has to make attempts to, what the law says, mitigate their damages, which means they have to try to find another tenant that would fill their shoes, same or similar tenant. They don't have to accept an inferior tenant to the one that they accepted. So it has to be somebody for equal or greater than the tenant that they had, and they cannot charge more in rent. They have to advertise it for whatever the tenant had agreed to pay, and for the balance of that lease. Now, frequently, if there was 9 months left on the lease, the new tenant comes in and says, well, I'll pay that in rent, but I want a year's lease. You don't have to, if they're going to get a year's lease, then you have to at least get the month, the amount you were getting from the previous tenant or greater, but that's going to release the tenant from the previous tenant from their obligation to pay. So rent is payable on the first of the month. Ours says the first of the month, and it is delinquent on the next day. So I always tell the tenant, you know, I'm going to, the rent is due on the first, I'm going to serve you on the second. So and I'm pretty hardcore about that. I never have to do it. I just have the understanding with the tenant right up front, and I just never had to do it. And I never have problems with tenants. I don't understand, you know, why some people do get, you know, you get problem tenants. But again, I believe you need to check previous landlords. So again, this just talks about, you know, if your tenant moves in on the 15th of the month, they pay for the last 2 weeks of the month. We're going to make them pay for the entire next month as well. We don't ever want to have less than a month's worth of rent. So if they move in on the 15th, we're going to charge them for a month and a half, and then they start over again on the first of the month. On the following, on the month after that, to pay just monthly. Okay. That's what this paragraph says. Payment, decide from the owner how they want to accept their check or their rent. I disagree with wiring and electronic payments, and the reason behind that, and we're going to see it in a minute, is because your NSF laws don't apply. Because it's not a check. Like I said earlier, we don't do pen pal or PayPal or whatever, or Venmo or Zelle or whatever those things. We just had nothing but problems with it. And if the owner has a problem, you can't help them because you're not a property manager. So rent shall be delivered. Here it is. If they bounce a check, if any payment is returned for NSF funds or because the tenant stops payment, then after that, the housing provider may require in writing that the tenant pay in cash for 3 months, and all future rent shall be paid by money order or cashier's check. So rent payments shall be applied to the earliest amount due or past due. Security deposit, again, we like that going to the owner. If you're doing property management, you're probably going to keep it in your trust account. Again, we want everybody to understand that the security deposit may not be in lieu of last month. So get out of the habit of saying first and last. You know, they pay their first month's rent up front and a deposit, if any, and we're going to see what that can look like. But we never use the word first and last, because then the tenant assumes that their security deposit is the last month's rent. And we're going to see some limitations on how much we can charge for security deposit anyway. So remember that you must return the security deposit to the tenant 21 days after they vacate the property. That means, remember the keys, they give you the keys. I've gone to tenants, tenants are moving out. They say, I'll give you the key when you give me back my deposit. And I say, well, that's going to create a problem for you because our agreement says that I don't have to give it back to you for 21 days. And I'm talking about property I own. So I don't have to give it to you for 21 days or an accounting thereof. And that's what the rest of this in Civil Code 1950, they can look it up. They have a copy of this, right? But I don't have to give it to them for 21 days. And that's just in case there are any weird bills coming in or things that they haven't paid or stuff like that. I have to give them back their deposit or an accounting thereof, where I took money out of that deposit. Okay, everybody good with that? One of those things that people just get going. So security deposit will not be returned until all tenants have vacated the premises and all keys have been returned. So do not be holding the keys hostage because I'm going to serve you. Okay. All right. Any deposit returned by check. This is the other thing. I've had like 5 people. Again, we've had a couple of properties where we've had 5 people. I want 1 check for the deposit, 1 check for the monthly rents. I'm not going to be accepting partial. Everybody is jointly and severally liable on the lease. So I want 1 check. And so when the tenants move out, I give 1 check back to the individual that gave us the deposit, unless everybody sends me something in writing that says that this is how we would want to have that dispersed. No interest is paid unless required by law. If the deposit obviously is held by the owner, they agree to hold us, not hold us liable for the return. If the security deposit is held in the owner's trust account and broker's authority is terminated before expiration, and the security deposit is released to someone other than the tenant, then the broker shall notify the tenant in writing. I have one of these right now. They did a great job. Property manager did a great job, and to whom the security deposit has been released. Once the tenant's been provided such notice, tenant agrees not to hold the broker responsible. So move-in costs, we like cashier's checks. You fill in these forms. So let's talk about the amount of security deposits. So no matter how you call it, cannot exceed 2 months rent. For an unfurnished premises, 3 months rent for furnished premises. So you call it whatever way you want to call it. If it's unfurnished, the deposits, that includes key deposits, pet deposits, all deposits may not exceed 2 months rent for an unfurnished premises. Everybody good with that? You could do an advance rent, and I've had that happen where my owner happened to be a judge. The tenant's coming to us from up the street on Mango Drive. The tenant had a UD, had an unlawful detainer, got evicted from a property. They came to us and they said, we want to pay the whole year up front. Okay, we can do that, right? Because it says right here, can't be less than 6 months rent, advance rent. Otherwise, the law thinks that it's a deposit, you trying to get around the deposit rule. And so it has to be at least 6 months. And in that case, by the way, the tenant paid the whole thing. The risk to the owner, of course, is that the tenant legitimately leaves the property prior to expiration of the lease. They may be entitled to get their money back. So that's a problem. Late charges, we're going to charge them after day 1. If the rent's not in by day 1, we're going to charge them 6% of the rents. Then we have our NSF laws. Again, if you paid by wire, you won't have the protection of the NSF laws. Let's see here. Parking, if you're going to charge them for parking, first of all, you tell them where the parking is, and then whether you're going to charge them or not. And if you're going to charge them, you have to tell them how much. Same thing with storage, utilities, who's going to pay for what. Usually the tenant doesn't pay the HOA dues, so we put that in here, but they pay everything else. And then we have all of our little check boxes. You need to be really good about this, folks. If you're doing a lease, make sure you check the appropriate boxes. If it doesn't have a gas meter, check the box. If it's on a sub meter, so for example, the Bluffs, the electric meter, it doesn't have nobody has a separate electric bill. What they do is they just 300 something units, and then everybody pays their share of it. That's kind of like a co-op almost, but they don't have separate meters. So for the Bluffs, we always check the box. Condition of the premises, I talked about this earlier. We have the move in, move out form. We have the tenant give us the move in form completed, within 3 days after they move into the property, because we want them to tell us what's wrong. If they don't give it to us within 3 days, then anything they give us is going to be suspect. They give us something 6 months into the lease and it talks about all the stuff that's wrong with the place, we're going to think the tenant did it, right? And then when they leave the property, they give us the move out form, and we compare the two forms, two separate forms now. Maintenance, anything goes wrong, we want to know about it. We're going to tell the tenant what they're going to maintain on the property. And then again, the refrigerator, washer, dryer very commonly are included in G. Let's see, tenant shall not use the premises to plant, grow, cultivate, or sell marijuana, because California law allows that, I guess. I don't know. I'm not a marijuana guy, but they agree not to do that. Neighborhood conditions, I always tell them drive by there at night. When do you sleep? From 9 p.m. to 5 a.m. Okay, you should be there at midnight to see if there are going to be any loud parties or anything else that's going to disturb your occupancy of the unit. Animals, we have a new form. It used to be the pet addendum. And so no animals by default. Now remember, a service animal is not a pet. So you want to be really careful. Do not charge a pet deposit for a pet that is a service animal. So I'll give you this. This is the lease rental chart. Again, with all the laws, what forms are needed in our leases. I've talked about most of those already, but we have this one, the landlord tenant law. And this says 2021, but I did pull up, and I didn't pull it up here to show you, but this is the Q&A on pets and assistance animals, service and emotional support animals. So again, I'll send this to you. Send me an email. I'm happy to send it to you. Can you completely ban pets in a lease? I'm going to tell you the answer is no. And so again, you cannot. Again, a service animal is not a pet. It is an extension of the person. Okay. So the answer is yes, you can ban them unless it's an assistance animal under fair housing laws. Now, the community may have a rule. So like the Bluffs, I'll use them as an example. They allow one cat, but they can't prevent a service animal. Okay. So they can create a rule that says no dogs, but they can't create a rule that says no animals of any kind, because they have to admit service animals or the like. So again, I'll make that available to you if you want it. Back to my form here. Smoking by default, no smoke. Oh, I wanted to show you that. Well, I'll show you the ATCA later. It's a cool form. I like that form. No smoking, period. If you're going to allow smoking, you check the box, only this kind of smoking. Rules and regulations, we're going to give you a copy of the rules and regulations. If it's a condominium or a PUD, then we're going to give you those rules and regulations. The owner may have their own rules and regulations. So we have to give you those because, for example, I had a couple of gals from the university renting one of my places on Stratford Court. And so, and I don't know what possessed me. I said, now, it was a second floor unit. I said, now, I'm sorry, it was a ground floor unit, but it was a 2-story horseshoe shaped building. I said, now, ladies, no jumping off the second floor into the pool. It was configured in such a way that they could probably hit the pool. But I don't know why I said that. Sure enough, about a week into the lease, and I had dad on the lease. So I had the two girls and I had their father, who happened to be an attorney out of LA. And I had him on the lease as well as a tenant. And so sure enough, I get this letter from the homeowners association, said, your tenant was jumping off of the second floor into the pool. And I'm sitting here thinking, I gave him the idea. I mean, what an idiot. So anyway, it comes to find out that they were so excited to have the rental that they decided to have a party. They brought the boys over. And of course, the boys were the ones jumping off the second floor into the pool. It's like, boys. And so anyway, so I went to the girls and I said, okay, I said, so I have an obligation to let all of the people on the lease agreement know about this $100 penalty. And the girl said, no, please don't tell dad. Here's $100. We'll pay it ourselves. And it'll never happen again. And these girls turned out to be among the best tenants I've ever had. In fact, they moved into another property I had in Carmel Valley just so they wouldn't lose me. So take good care of your tenants, be upfront, be honest with them, tell them how you're going to deal with things. Okay. So, Alterations and repairs, again, they are not allowed to do repairs on their own or deduct it from the rent. What keys are we going to give you? Here they are. I tell all the tenants the property hasn't been rekeyed. I'd put that as the default. If it has been rekeyed, then I'll change it. We get to enter the property. 24 hours is considered reasonable and sufficient notice by law and by contract. We changed that in our addendum to say that 4 hours notice. But again, anytime there's an emergency, then we can enter right away. I mean, we don't have to stand by with water piling out underneath the front door. We can enter the property. We're going to knock, but we're going to enter the property to stop the water leak. So KLA again, photographs and internet advertising. Tenant needs to be aware people take pictures of stuff. Signs, we're going to put up a sign. By default, our contracts say no assignment or subletting. We're not going to allow that. And we don't check this box. So in other words, they may not turn our property into a Airbnb or a VRBO or anything like that. Again, I said earlier, they're jointly and severally obligated to the lease agreement and to the monies. Possession, believe it or not, the owner doesn't have to give them possession of the property until 5 days after the lease begins. If they don't do it within the 5-day period, the tenant can cancel the lease. But the contract by default says they've got 5 days. We change it to 0 because we want them moving in right away. Tenant's obligation upon vacating the premises. Remember that the law says the tenant only has to return the property in broom clean condition. And so we have a separate thing that we write that says that it'll be professionally cleaned, including windows. Provide us with the receipts. Okay. So again, right to pre-move out inspection repairs. We have an obligation at law to tell them that they have the right to do all that stuff. Even though we're not going to be present because we don't have a contract with the owner after they move in, right? Breach of contract, early termination. How do we handle that? Temporary relocation. So the building has to be bagged. And so you own a condo and the whole building is going to be tenanted. Well, then you have an obligation to put them up into substantially equivalent housing. So tenants shall only be entitled to a credit of rent equal to the per diem rent for the period of time the tenant is required to vacate the premises. Damage, guess what? You're paying for it. I like that move-in form. And unless the property is deemed to be uninhabitable, in which case, we may have to make other arrangements. Insurance, yes, we do. We tell everybody we do not have insurance to cover your toys. We do require tenants to have insurance. And so in an amount at least of 250 grand, they thank us for that later. The cost of that policy is not very expensive. I think it's $100 a year. So it's not very expensive, but we do require them to have insurance that names us as an additional insured. The advantage to that, by the way, is that if they cancel the insurance during the lease period, the insurance company notifies us. Water beds, I don't know what our fixation is on water beds. They have the same weight displacement as a refrigerator does, but we just seem to have this thing about water beds. So notice, you got to put in the housing, who's going to receive notice service of process on behalf of the owner, and then the tenant is usually in the unit itself. And then there's my tenant estoppel certificate. Folks, if you're doing leases, have them sign this at the time of the lease agreement. Really, really important. Okay, so because we're going to have to give that to the purchaser, right? Tenant representations, I think that's pretty obvious. Housing providers representations, there are no notices of default or delinquent amounts or any bankruptcy proceedings. Mediation, again, much like my listing agreement, everybody agrees to mediate first. Attorney's fees. So a prevailing party, we're going to limit the attorney's fees not to exceed $1,000 unless you change that amount. Most of your cases between the tenant and the rental property owner are going to be held in small claims court. So you want to limit the fees, but attorneys will sometimes try to get them into superior court so they can get their fees. But by contract, we're going to limit it to $1,000. Let's see what else. Disclosures. We have all the, remember those disclosures we talked about with the owner? Here they are. We've checked the residential environmental hazards booklet, which I'm going to pull up for you in a second. There is a TFHD form, the tenant flood hazard disclosure. It's a statutory form. I'm going to show you that one. Let's go in there and I want to show you these forms. Okay, so there's a lot more in here, but most of this we've already covered. So let's take a look. I'm going to take us back to our remember over here, lease packet. Here's my environmental. So here are the 6 parts of that package. So I've got my residential environmental hazards booklet, my protect your family from lead. Remember, required by law in California, whether it's pre-78 or not. Home energy rating pamphlet, our homeowners guide to earthquake safety, our earthquake hazards, and our homeowners the signature page. So all of these are signed by the tenant. There is a signature page. Page number 6 is our signature page. Let's just pull that up really fast so you can see what it looks like. Full screen. So this is our guide. Again, we don't have natural hazard disclosures in this, but make sure that if you're doing a sale, make sure that the company you're using for natural hazard disclosure has these forms in it because they're required by law. Again, there's my sign off on that. Okay. Let's see, anybody have any questions so far? I'm going to go back to, there's my packet. I wanted to show you the tenant, the flood hazard before I go back into the balance of the lease agreement. Let me see, where is it here? Here's my tenant estoppel certificate. Where's my tenant flood hazard? The interesting part about it is San Diego actually publishes, where did it go? Linda? Oh, I probably have it under the listing packet. That would make sense. I need to move that. Oh, well, I'm sorry. You know what? It's actually in the lease. So let's go back to our lease. Pull that up, go to full screen, scroll way down because we've gotten quite a ways along down here. Where were we? Here we are. So we're going to have, actually it's attached to this document. So we're going to look at it there. Service Members Civil Relief Act. Listen, if your tenant gets orders, if they're in the military and they get orders, let them go. Okay, thank them for their service and let them go. I had 2 Marine Corps helicopter, 2 girls, sisters. They were Marine Corps helicopter pilots living in a property I owned on Portofino. They stayed with me for years. They were excellent tenants. And of course, if I'm going to have trouble with the military, I'm going to call the CO, but I never had to do that. They're great tenants. And so, one day they called me up, they said, we got orders. And I go, oh no, I was so upset because they were great tenants, but listen, here's your deposit. Have a nice day. Thank you for your service. Okay. So do not mess with that. That's serious violation in California. Time of essence, there's all that stuff again. Now we have our confirmation. So remember, we had disclosed the concept of agency, but then we must also confirm agency, and that's what this does. Termination of agency relationship. Notice down here, delivering to tenant the keys or other means of entering the premises. That's our policy. You check with your broker what your broker wants. You could have it tenant occupancy, but it's going to terminate. Our relationship is going to terminate. We want everybody to know we no longer have, anything we do after you get the keys is legal advice. So we're not going to do that. Okay. All right. Let's see. Believe it or not, notice the right to receive foreign language translation. That's the law. And so those are the 5 languages: the Spanish, Chinese, Korean, Tagalog, or Vietnamese. We have an obligation to let them know that they can receive those translations. We don't have them, so they would have to get those on their own. Okay. Let's see here, receipt, if we're going to receive move-in funds, which we don't. Other terms and conditions. So we have our KLA, lead-based paint, if applicable. We definitely have the lease rental mold addendum. Parking and storage disclosure if there's separate. Bed bug disclosure by default, tenant flood hazard by default, rent cap and just cause addendum. So let's go down. Again, we have our legally authorized signer signing on behalf. Here we have the entity tenant, if any. I've got a couple of those right now. We also have guarantee, otherwise known as the guarantor. So the person that's willing to guarantee the tenant's paying the rent and abiding by the lease agreement. Again, here's my housing provider's information. I'm going through here quickly because I'm trying to wrap this up. But notice we're only halfway through the forms. Then we have our bed bug disclosure. It's required by law. It's Civil Code 1954. This is something that, you know, we give the tenant notice of all these things. If the owner is aware, if the tenant reports suspected infestations and it turns out that it is infected, then you may not rent it again until you get it fixed. Okay, that's the bed bug disclosure. Then here's my tenant flood hazard. We do this on all of our leases. We check the box that says it is in a flood hazard zone. Why? Because just like my natural hazard disclosure, I'm gonna essentially prevent the lawsuit. If it's not in the zone, I'm sorry, if it is in the zone and the default says it's not, and I don't check the box, then I've told them it's not in the zone. If it turns out it is in the zone, then they can come after me. They can come after the owner for telling them that was not in the zone. I think CAR needs to flip that and make it so that the default says it's in the zone. You can always say it's not in the zone if you know for a fact that it's not in the zone. There's a great website for this, and it's right down here now, the HTTP site right here. San Diego has its own site. You can just look it up. It's the and they have you type in the address of the property. It tells you whether it's in the zone or not. We usually print that, give it to the tenant just to cover ourselves on a rental. Rent cap and just cause addendum, as you all know, a couple of years ago, the current governor created the Civil Code 1947, which was statewide rent control. Again, California law limits the amount your rent can be increased, et cetera, et cetera. And so, you know, I always refer people to this citation. Also provides that after all tenants have continuously and lawfully occupied the property for 12 months or more, or at least one of the tenants has continuously occupied it for 24 months or more, a housing provider must provide a statement of cause in any notice to terminate a tenancy. That does not include necessarily the lease that occurs that terminates by natural causes. There's no obligation for the owner to re-rent to them. I think for San Diego, I think has created an exception to that. So definitely check with your attorney. We check the box. In most cases, our owners are going to be exempt, but here's the rules. Property meets the requirements of the Civil Code, and the owner is not one of any of the following: a real estate investment trust, you know that to be a REIT, or a corporation or an LLC. If they are any of those things, then they are not going to be exempt. Okay, so and then the rest of it, there's nothing else to do, but it's got really good conversation about just cause reasons for termination, whether at fault or no fault, just cause notices, whether again at fault or no fault, and then other restrictions may apply. So I always refer people to this document when they ask me whether or not they can get rid of a tenant. Here's my fair housing discrimination advisory again towards the end of the form. I think it should be at the beginning. And then we've added information on dampness and mold for renters in California, and that's going to be the last form. It's got some really good stuff in there. So again, that's going to complete our lease rental form. I do want to talk about our application to rent. And then I want to do the templates for you really quick. So here's the application to rent form. I'm going to go full page on you again. Notice that these areas here are not something you can fill out. You should not be filling these out. You could print them and have the tenant fill them out in their own handwriting, or you could send it to the tenant to complete online. I would send this to every applicant, and then they can complete all this stuff. They'll put in their name, birth date if they want to. We really don't want that, but okay. DL, all that stuff. If you're going to ask for it. So they fill in all this stuff. Know that here it says, have you ever been a party to an unlawful detainer or filed bankruptcy within the last 7 years? The one that I get asked frequently is, have you ever been asked to move out of a residence? Have you ever been convicted of or pled no contest to a felony? So we can ask that question. We cannot ask if you've been arrested, but we can ask if you've been convicted. Doesn't mean you're not going to accept them, After completing the review, housing provider may consider the nature of the felony and the length of time since it occurred, so long as the felony is directly related to the applicant's ability to meet its obligations. So if they have a felony conviction for embezzlement, I would say that's probably relevant. But if it's if it's a DV, a domestic violence, then I would say you need to look at what you're inheriting, right? That kind of thing. Residence history, I want to call previous landlords, right? Probably not the most recent landlord may not be the best source because they're going to be obviously the one most vested in the interest in getting rid of them. And then on page 2, credit information, we really need to have that. Have the tenant fill it out, because you've got to, if the owner has to chase them later, they're going to come after you if you didn't have this completed. Banking information, references, nearest relatives, how do we get a hold of next of kin? And again, the applicant understands this is an application to rent only. It does not guarantee that you're going to get the property. Applicant will provide a copy of the driver's license upon request. As I said earlier, I prefer to have that happen after the lease comes together. And then down here, they can check the box if they want a copy of their credit report. You cannot give them the credit report that you obtain. Usually most of the credit reporting agencies require that they go to them directly to get it. So they're entitled to a copy of their credit report, but they have to go to the credit reporting agency directly. Okay, all right. And so we have them sign it. If the application is not fully completed, or if section 2, paragraph 2 is applicable and the application received without the full screening fee, the application will not be processed. The application, any portion of it, will be returned. This is their authorization to run the credit, property information screening fee. This talks about all that. I filled in the language for the SDAR website that they can go to fill out their own application online. We don't want their money. Smart Union by TransUnion, et cetera, et cetera. There's my burn again. We need to let them know by law. We have to tell them that we are investigating them, and here's the service we're going to use to do that. Okay, everybody good with that? Let me get into, I want to show you anything else in there. Nothing else that jumps out. I mean, obviously this could be a 5-hour class. So let's go back. I'm going to go back to my list here really quick because I want to show you how to create a template. And again, I will make the template available to you if you want it. Here's the lease template. But how do you create the template? You're going to go up here. You're going to click on new. You're going to click on new lease listing or new lease template. You're going to give it a name. You're going to call it residential, probably. I'm going to check the box, do not automatically apply it, but let's say you check the box. In fact, I will do that. I will automatically apply this template to lease listing residential new transactions. And so, because I'm going to create a template that I want to use, that'll automatically be applied. Okay, so I'm going to hit my save button, and then it's going to say, okay, what forms do you want in there? All right, so now here's what I'm going to show you how to do this, but I am willing to send you my lease template. So if you send me an email, I will send you my template, make it really easy. So I'm going to put in my forms. Again, I'm going to go over here, click on all. I'm going to go to lease. Let's see, I want to do this differently. Let's go to the lease forms. And so let's pull up a couple forms really quick. I'm going to pull up my cover sheet because it's going to require that I do something with that. But let's do the residential lease agreement. Where is it? Here we go. Residential lease or month to month. I'm just using this as an example. Again, you saw I have a lot of forms in mind, and I'll send you that. I'm going to show you how to do this. So I'm going to go ahead now, and I'm going to fill in an owner's name. Better yet, let's make this even better. I'm going to go ahead and I'm going to apply my template. So, and the reason I'm doing that is because my template has all the lease stuff in it, and I won't have to fill in a lot of these things. So when I do that, look, boom, there's all my folders, there's all the forms in the folders and all that. So now I've created a template. I've called it FGH, MG, FG, whatever. I've created it. So now I've created my template. I'm going to go back to my list. Here's my template. I'm going to go, whenever I go to create a transaction, I'm going to go to transactions. I'm going to say new transaction right here, and I'm going to call it a new lease listing in this case. And so I'm going to give it a name. I'll just make something up. I'll click on the box that says it's residential, active. I could put in the address, that's okay. But again, I'm just creating this. Now they're going to require me to decide whether or not Rent Spree is going to be this tenant screening thing. That's just a deal they made with Carr. And then I'm going to select the template. Well, I'm going to select the one I just created, which is this one right here. So it's going to add that template. I'm going to click on the save button. And now it's going to create a new transaction for me with all of those forms in it. Is everybody okay with that? I want to make sure you see how easy this is. And I know I'm in a transaction because it's going to create the archive, but now I have all my forms in one place. Everything is saved and ready to go. Okay, everybody understand? So again, what I did was I created a transaction, and I used my template to have that transaction. That's how you create your template for what? Remember, we have also the template for, the seller listing template, the buyer offer template, the property management template. We do everything by template. So, all of the stuff, we do the same thing for everybody. And that's pretty much, I can't believe it. I'm gonna let you go a little bit early. Hang on a second here. Let me finish off my PowerPoint. If you have questions on that, let me know. Okay. But we have a residential lease month to month. I showed you that. I showed you the short-term. Why is CAR eliminating the short-term lease or rental agreements? And mainly to protect the licensees from being potentially complicit when the owner doesn't pay the TOTs, right? And so like Del Mar, for example, people do short-term rentals, the racing rentals, 7 weeks. So you have to pay, the owner has to pay the tenant occupancy tax. Well, they tend not to do that. And so that's one of the reasons why we're getting rid of those short-term rental agreements, the transit occupancy tax, there it is. Lease listing template, I showed you how to create one. And so again, I am going to let you have just a couple minutes early. So any questions on anything that we've covered here today? Please ask them. I'm happy to help, happy to answer the question. If you want to view any of the previous webinars, you can visit the YouTube website. I learned how to create a YouTube website. I learned how to create a QR code. So this is the QR code. So if your phone has a QR code reader on it, you can just click on this. It'll take you straight to the YouTube website so that you can look at the webinars. Okay. So, or you can type in your browser at Burke Real Estate Consultants, Inc. And that will take you to the YouTube website. Or you can go to the bit.ly website, which I learned how to create too. That's bit.ly/real-estate-ed. And again, case is important. So all lowercase. I had to create this because we're going to be posting my RPA was approved for 5 hours of continuing education credit. And so whenever STR gets around to let me teach it, we're going to have to post the forms up there. It's a DRE requirement. So you'll be able to pull the forms down at any time, take a look at what they look like. And then, I was honored by the department. When I sent in the RPA, they called me on the phone and they said, we're really looking forward to reading your dissertation on the RPA. I wrote an 18-page dissertation. So, wow, that's very exciting for me. So please remember to like and subscribe. I was just honored when I saw how many people have actually liked my presentations. It makes me feel good. I don't get paid for it, but it makes me feel good. And then subscribe. All that does, when you log back into YouTube, it just lets you know that I've done an update or I've created a new one. Okay, so it's for your benefit. That's all I ask. If you have anything that you want us to talk about, somebody hit me just before this class. They hit me with the actually another ex-Marine who can you be an ex-Marine? I think you're always a Marine, right? So anyway, she says, you know, I need some help on the RLA. Where's your webinar on that? So I'll have to look, but I'm going to respond to her to have her take a look. But we need to do the RLA again because it's changed again. And I've already talked to SDAR about that. I need to be doing the RPA, even the short-term version, 4-hour one that's not DRE credit. The live one, the 5-hour one I must do in person. So I'm trying to get on their calendar for doing that. But the ones I do online are not for DRE credit. So anyway, please send them an email. Say, will you let Kevin do the RLA, or let Kevin do the RPA, or let Kevin do the BRBC? Copy me if you want. Send it to me. Copy them. It's okay. I'm talking to them right now about doing that. So anyway, weekly email updates. If you're not getting the email, then please, I don't, everybody is opt-in. I don't just put people in there. So if you're not getting it, let me know. If you want to get it, let me know, whatever. So there's my email address. If you need to get a hold of me, happy to help you in any way that I can. And I do want to thank you for being here. And we're rolling up on the Labor Day weekend. And I wish you the very best of success. I hope that you have a chance to enjoy some time off. I will be working the entire weekend. I've got all kinds of fun stuff already scheduled to do. But frankly, as you know, I enjoy what I do. So I'm looking forward to it. So if there aren't any other questions, again, anybody have a question, put it in the QA field. If you don't have any, then I want to thank you all for being here today. And as we say from my hometown of Del Mar, I look forward to seeing you around the track. Take care, everybody. Bye-bye for now.